and thank you for joining us for a special end of summer session of our in-house Counsel CLE webinar series. Before we get started, I have a few housekeeping notes. For the benefit of all participants, attendee lines have been muted. Should you have any questions that you would like to submit during the event, you may submit them through the chat box at the bottom of your screen. If we cannot address your question during today's webinar, we will follow up after the program. Please note that today's webinar will be recorded and circulated to all registrants via email after the event. Should you have follow-up questions at that time, please reach out to any of the key contacts listed in the email communication. Please note, Dentons can only issue CLE credit for attendance during the live broadcast of the webinar. The following is a very important message regarding CLE credit. The webinar window must remain open for the entirety of the program, and it must be the only window on the forefront of your screen. WebEx will detect if you minimize the program or use the computer outside the webinar software. This will prevent your earning CLE credit. One other important note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, please be sure to listen for the code word given during the program. When prompted, you will need to enter the code word into the Q&A section of the screen. If you don't have a license in these states, you can disregard this. And now I'll kick it over to John Cotton Richmond to introduce our first presentation.
Thank you so much, and I'm thrilled that everyone is able to join today. We'll go ahead and advance to the next slide. As we're thinking about these CLE webinars, an important topic right now is supply chains and strategies that we can deal with the new and quickly evolving legal landscape around human rights issues within supply chains. I'd love to provide a quick overview. Go to the next slide. You know, we're going to talk a lot about a few different laws. Obviously, the German Supply Chain Act is going to take effect on January 1st of this year. We're very interested, and we've got an incredible expert to share with you today from Germany's perspective on how this law is going to be implemented. But it's not just the German law. We have the due diligence directive out of the EU that Parliament will be considering soon, as well as the management of supply chain issues through trade laws. We just got a new decision from the EU on Monday regarding a forced labor ban. They will operate quite differently, but perhaps complementary to the U.S. Tariff Act and the new Uyghur Forced Labor Prevention Act. So we want to talk about how all these things interrelate, and then we'll have some Q&A at the end. Go to the next slide. I'm thrilled that we've got experts here, and two of my colleagues here at Dentons, Birgit and Raj, are going to give you a significant amount of information and put it into a context that is usable, something practical that you can take back and think through your own supply chain and risk mitigation efforts. Next slide. So as we think about this, the current landscape, I think, is quite confusing. There's a lot of different pieces all happening at the same time, and it comes under a new umbrella. If we go to the next slide, that people are calling ESG, this three-letter acronym that no one was using 4 years ago, and now everyone is trying to figure out. It represents a lot of lines of effort that have been pre-existing, all repackaged and relabeled, but with a new emphasis as we think about environmental, social, and governance responsibilities that companies have. There's a lot happening in this space, a lot of attention is being paid to it, and a lot of questions are being raised. If we go to the next slide, or one prior, there we go. You know, what we've seen evolve over the last decade or so is a disclosure framework. And it started with the California Transparency Act, was followed up by the United Kingdom's Modern Slavery Act, and then ultimately the Modern Slavery Act in the UK, in Australia. All of these disclosure provisions were basically tell us what you are doing, companies, if anything, to deal with forced labor or human rights abuses in your supply chain. There weren't mandates to do anything other than make the disclosure itself. The next slide. We are moving out of sort of the murky waters of disclosure into the firm land of diligence. There's a big transition happening here, because what Birgit's going to share with you about Germany's act and what we're seeing in the EU is a shift from just making disclosures to mandates that companies have to take action to actually map their supply chains, to figure out where abuses are happening in their suppliers efforts, and it's going to change where burdens lie. I'd also, as we go to the next slide, just encourage you to think of this as a paradigm shift. We are flipping the script in terms of who bears the burden. For years, we've asked governments to be responsible for enforcing human rights obligations, and now we're shifting to requiring companies to move to the place where they're making sure there's not human rights violations as we go forward. The next slide. Again, as we head into the rest of this session, I'm excited that Raj is going to give us a foundation in where all these obligations stemmed from legally, and then we're going to shift to this German supply chain law that I'm very curious to hear Birgit's presentation on, because as I said, it's going to take effect in just a few months, and it is a game-changing piece of legislation. So with that, let me kick us off and shift to Raj to walk us through how all these obligations came about.
Well, thank you very much. It's an honor to be with all of you, and of course to serve with Ambassador Richmond and Dr. Brigitte. As Ambassador Richmond has said, basically we are all now human rights lawyers and national security lawyers. Those of us who think trade is just about trade and tariffs and non-tariff barriers, well, that era is over. We need now to secure and risk manage our supply chains for human rights concerns. Next slide, please. So what are human rights? Well, there's several sources of human rights law. The most obvious one are what are called the United Nations International Bill of Rights. But there are also rights that arguably are human rights, or at least at the margins of what are accepted as human rights. And they include International Labor Organization, internationally recognized worker rights, and some provisions we've now seen in free trade agreements concerning the rights of women and the rights of people based on their sexual orientation and gender identity. So we need to be aware of these three different sources of human rights. Next slide, please. The foundational document is, of course, the one that was drafted by our own First Lady, Eleanor Roosevelt, as part of a drafting commission back in 1946 and 47, and that came to fruition in 1948, the Universal Declaration of Human Rights. And you can see the voting in the first point on how that went. That UDHR, which is now accepted by all roughly 193 UN members, has been supplemented by two covenants, a covenant on civil and political rights and a covenant on economic, social, and cultural rights. Both of those covenants entered into force in 1976. So those three documents, plus some optional protocols, are what we call the International Bill of Rights. Next slide, please. As I mentioned, that there are 30, or as I was about to mention, there are 30 articles in the UDHR. Next slide, please. And here's a brief overview of them. We won't go through all of them, but I'll just put some highlights for you about the rights that we are talking about in terms of securing supply chains and risk managing. Some basic concepts of human dignity and liberty that come in Articles 1 and 2. A prohibition against slavery and against torture that comes in Articles 3 and 5. And the idea familiar to us as lawyers that human rights need to be enforceable under local law in Articles 6 and 11. Next slide, please. We also see some distributive justice rights and some constitutional liberties, and even some rights about healthcare and an adequate standard of living. And some rights how the individual ought to be able to exercise what's called legal justice. Next slide, please. The UDHR is not legally binding. It's not customary international law, but the general consensus among lawyers, given that this document has been translated more times into more languages, 530 than any other international legal document, is that most of it, or several of its articles, are indeed at least customary international law. Next slide, please. So the two covenants I mentioned earlier, they supplement and elaborate on the Universal Declaration. They have been accepted by most, but not all, of the UN members. The notable ones that have not accepted it, of course, is China. They are enforceable by the United Nations Human Rights Committee, about which we may say more later. Next slide, please. On the economic and social rights, which is enforceable by a different body at the UN, again, we've got most members are most UN members are state parties, but actually the US has not yet ratified that particular covenant, and that one deals with education and health and standards of living. Next slide, please. When we come to the ILO, an organization founded basically back by the Treaty of Versailles and was working with the League of Nations and then morphs into the UN system. There are 5 key or top 5 internationally recognized worker rights: association, organization, and collective bargaining. That freedom that we're going to see again from forced or compulsory labor that comes up in UFLPA. The minimum age against child labor, and then some minimum working standards and working conditions. Those are your top 5. Next slide, please. Most of those are accepted by all ILO members. There are about 187 member states. And they have long been part of the US Generalized System of Preferences scheme. In other words, you can't get GSP treatment if you don't adhere to those top 5 labor rights. Next slide, please. The ILO itself has over 180 conventions. Here are some of them that most members, including the US, have ratified most of them, but again, not all of them. Next slide, please. And the ILO itself says these are its most important 8 conventions. So as you go back after our webinar, you'll be able to look back at these slides and then go right to these conventions in your own legal research for your own companies and clients and find out exactly what they say. Next slide, please. The newest, and not the newest, but one of the most important ones recent ones concerns the prohibition on child labor, where a child is defined at age 18. And this, of course, also is a prohibition that relates to human trafficking, rules against prostitution and pornography and illicit activities of children, and cleaning up supply chains from those vices, if you will. Next slide, please. So the ILO members are obliged to take immediate and effective measures against child labor practices, and many of them have done so. The US ratified this particular convention, and as we're going to see with Dr. Birgit's presentation, there's definitely movement in the EU and Germany, as well as the US, on implementing these sorts of rules. Next slide. And that's what this slide says, that the EU and Germany are indeed implementing some of these ILO conventions. Next slide. Now, the third area to conclude this part of the presentation, where we are seeing as a source of human rights for trade and supply chains, are free trade agreements. TPP in Chapter 23 specifically recognizes the need to enhance opportunities for women, including workers and business owners, to participate in the economy. Next slide. And so it calls on the parties, and notice the modal and lexical verb here. The modal verb is shall, the lexical verb is consider. So it's soft law. It doesn't say shall criminalize. It says shall consider undertaking cooperative activities. And those are the cooperative activities in A, B, and C. And by playing, if you will, with the modal and lexical verbs, we're seeing in the FTAs at least the entry into them of soft law provisions on the rights of women. Next slide, please. And in USMCA, we see another major evolutionary step, and that is the inclusion you'll see in Article 23.9 that says protection against employment discrimination, including on the basis of sex, sexual orientation, and gender identity. That's the first time we've seen in the history of U.S. free trade agreements, and USMCA is U.S. law. TPP, of course, the U.S. withdrew from. We've seen such a provision. Next slide, please. Now, again, it's still soft law, and there's this rather, dare I say, shocking footnote that in Article 13, in footnote 13, that the U.S. inserted, saying, well, we already comply with this provision. That's not been tested, but there it is anyway. Next slide, please. So with that, let me turn it over to my colleague, Professor Brigitte.
Thank you so much, Raj. Thank you very much, John, for inviting good old Europe to this seminar. We will dive and cover together the German Supply Chain Act, an outlook to the European, the draft at the moment, draft European Corporate Sustainability Due Diligence Directive, and some questions of indirect application of these type of supply chain laws, because the direct scope of application is one thing, but the poor guys who are squeezed are sitting in the supply chains. Next slide, please. Raj has already pointed out that the UN Guiding Principles on Business and Human Rights are the blueprint for all supply chain legislation in the EU. It kicked off with the French Loi de Vigilance, which was actually following the UNGPs and implementing them in the widest sense, but also including environmental provisions or environmental protection into the law. The German Supply Chain Act, coming into force on January 1, 2023, will also cover both negative impacts on human rights, but also beyond the UN Guiding Principles on the environment. What we see, that's not all. What we see happening is also increasingly national legislation, both in the Netherlands. We have seen the Child Labor Due Diligence Act, which will most likely never come into force, but will be replaced by, so at the moment, a draft act on responsible and sustainable international business conduct. The Netherlands has drafted also a broad act comparable to the French Loi de Vigilance and the German law, but according to the information we have, they are waiting for the European directive to come into force before they finalize their own act. The same seems to apply to the draft Belgium Act, which is following a similar route. The European Commission, one of the reasons why the German Act was actually enacted and not waiting for the European directive, was to really force the European Commission to do something, because whenever there is a need for harmonization, the European Commission is called in. And what we have seen since February is a proposal and a draft EU Corporate Sustainability Due Diligence Directive, and we'll come back to that later. Next slide, please. Let's have just a very brief look on transnational supply chain regulation. The German Act, as the French Act, are celebrated to be really hard law with hard sanctions, and therefore they are celebrated for really having a tough enforcement regime. The problem is, however, when you look at all these acts, the German Supply Chain Act, John was mentioning the UK Modern Slavery Act, Loi de Vigilance, the Dutch Act. They are similar, but not the same. And they all come together when a Bangladeshi textile producer wants to produce for actually customers in these countries who are obliged as hard law to actually follow a hard compliance regime. And this is something which is eventually overburdening the Bangladeshi supplier, that he will say, I will only produce for the German guy because I cannot do a compliance system with all these laws. Or what we've seen in the past as well, they are turning the back on us and they say China is easier, no strings attached policy, we'll do business with them. Next slide, please. So the challenges are, on one side, of course, they are celebrated for that, the extraterritorial reach and effect. of the German Act, but of course in the supply chain, and we as Dentons with some 10,000 or even more clients, we are sitting in the supply chain and we realize what that means actually for suppliers of services and of goods when you are approached by clients coming from different legal backgrounds and they want to all enforce their rules, their soft law, codes of conduct, etc. It's what's called rule jungling. We are also seeing actually pushbacks based on national sovereignty, not only with regard to the accord in Bangladesh, but also China has enacted some kind of counter-regulation in order to prevent European laws to become effective on their grounds. So what we are facing are pushbacks, negotiations, enforcement actions, and of course, tremendous compliance cost, and also a lack of legal security. And we see the creation of dilemma situations. Next slide, please. Let's dive right into the scope of application. The German Supply Chain Act directly has a direct and indirect scope of application. The direct scope of application is that companies are covered irrespective of their legal form, which have their head office, principal place of business or headquarter in Germany, and which have, as of January 1, 2023, 3,000 employees, threshold lowered in 2024 to 1,000 employees in Germany. The GSCA indirectly covers, however, also all companies in the supply chains of German companies, and they are suffering without actually having the possibilities to run the show as the directly subject companies can do. Next slide, please. So what's a supply chain? There is a definition, all products and services of a company, and it's a cradle to grave approach, actually from the raw materials to the delivery of to the end customers. Next slide, please. The Supply Chain Act has kind of three distinct areas with partly different legal schemes. One is the company is responsible for its own operations, but also its own business area, meaning also its subsidiaries it controls. So there is an element of group responsibility, which is based actually also on the economic unit doctrine, which we know already from European antitrust law. Then there are direct suppliers, and these are the contractual partners, and there are indirect suppliers, which are where there is no actually contractual relationship. The first two categories, a risk management regime applies. For the third category, the indirect supplier, the risk management regime applies only when there is reason to believe that there are significant negative impacts on human rights and the environment by the indirect suppliers. Next slide, please. Raj has already actually spoken about the legal positions and the German Supply Chain Act referencing in its annex actually UN and ILO, the 8 ILO conventions. The problem is the following. All of these conventions have been implemented by Germany into detailed German laws. So the question arises, if we have another layer established by this Supply Chain Act making direct reference to the conventions which have a kind of a programmatic character, what does that mean in relationship to the existing specified laws? Are they superseded? Because what the German bar tried to achieve is kind of an application only for supply chains outside of Germany did not come into law. So it applies to internal supply chains as well. The legal protection positions are defined by reference to these programmatic conventions, and we expect that the German Supply Chain Act, at least certain of its very broad positions, will end up actually in courts. In particular, actually, we will see constitutional challenges because it's the question arises whether it's actually defined enough to be directly applicable to companies. Then we have also a definition of what a risk is, because it's about risk management, and its a violation is because it's about remediation violations. Next slide, please. The core, and John has referred to that already, is due diligence. Due diligence not meaning the M&A due diligence that you have to check how a company looks like, so to speak, in terms of value and compliance. Due diligence means also protection of third parties, which can be affected by the company or actually those suppliers in their sphere of influence. And what you see here is the full program that you have to do, establish a risk management system which applies to yourself, to your own actually area, in particular the subsidiaries controlled by you and your direct suppliers. And you see a risk management system includes a representative, includes risk analysis, a policy statement, what you're kind of including also supplier code of conduct, preventive measures, taking of corrective action, being mitigating or rather remediating any kind of negative impacts. It includes a complaints procedure and also due diligence with regard to risks at indirect suppliers in case actually the indirect supplier, you have reason to believe that the indirect supplier violates these conventions. And then in the end, it's documentation and reporting. So it's from scratch, from cradle to grave. Next slide, please. What does it mean for companies? It means you have to beef up your compliance management system in order to really actually answer these requests. The question of appropriateness of due diligence measures, insofar actually certain criteria have been established in the Act, depending actually, for example, business activity, then the influence you have, the severity of the breach, reversibility, and of course the contribution to the risk or breach. What the German Act does not include is actually to establish a separate liability regime. It refers, however, to the existing liability regimes of tort law, for example. So this remains unaffected, but there is not an additional liability. This will change with the European directive. We'll see that. Next slide, please. Concerning enforcement, we have actually the possibility that someone who wants to assert a claim can entrust a domestic trade union or NGO with his representation to give it more power and leverage. And then we have a combination of all kinds of enforcement mechanisms, administrative control and enforcement by the BAFA, coercive fines, monetary fines, and exclusion from public procurement procedures, all applicable together with existing liability schemes cumulatively. So there is not one and for all. We will see whether all these requirements can justify the constitutionality test. In France, actually, the criminal monetary sanctions were cancelled by the French Conseil constitutionnel because they were considered to be too vague. Next slide, please. So what's next? We will see as of January 1, 2023, the Act will go live. The BAFA is issuing guidances and has issued already guidances with regard to specific provisions of the Act. We have ministries can issue but don't have to issue additional regulations to specify requirements, and we will see that the German Supply Chain Act will need to be revised and amended if the European Corporate Sustainability Due Diligence Directive is enacted and comes into force. Next slide, please. So let's turn to the draft directive on corporate sustainability due diligence, CSDD. Next slide, please. The process is still at an early stage, and we do not expect that the CSDD will be enacted anytime soon because Europe is going into a recession with all the problems we have on our lap at the moment. and the industry is lobbying hard not to have, on top of everything else we have to cope with already, a very demanding supply chain act. So when this is coming into force and how is not clear yet. Therefore, I will only skim through the provisions to give you an overview of the most important ones. And the present draft, this is clear to say, is wider and tighter in a number of respects. What the European Commission did, they seem to have decided that it's not going to be a regulation directly applicable in the EU member states, but it's going to be a directive which needs to be implemented by national legislation. The second question is, will that be a full harmonization, meaning that it has to apply the same way in all the member states? Or will that be what I expect, a minimum harmonization, meaning this is the minimum applicable all over the EU, but if national laws are more demanding, they will stay in place. And this will most likely happen to the scope of application. Next slide, please. Where the CSDD seems to be a little bit narrower because only specific company forms shall be covered, but the threshold is lower, 500 employees, but higher insofar as an annual turnover will be required. And we have specific provisions for certain high-risk sectors. Next slide, please. The CSDD will cover the whole values chain upstream and downstream, so no escape. It will apply to established business relationships, so not to any random one. And it will encompass direct and indirect suppliers without any difference. The subsidiaries, we will see probably a separate provision. Next slide, please. The legal provisions Raj was already referring to will be derived from a much larger number of human rights, ILO and environmental conventions, where we will face, however, the same problem of applicability also within the European Union and the programmatic character, the question of legal certainty. And then we see also a due diligence regime, but it's going to be slightly different than the one designed by the German Act. Next slide, please. We will see prevention and remedial measures, and we will also, that's important, cooperation between companies to increase leverage. This is something which has attention to antitrust laws, and the European Commission is working on that to allow for actually cooperation when it's for a good purpose, for sustainability purposes. And then we'll also probably see contractual assurances in order from the direct suppliers, but then also contractual cascade, and eventually the European Commission will draft model clauses which can be applied to direct and indirect suppliers. Next slide, please. The remedial measures is to end negative impacts and in addition to compensate negative impacts where the question arises. So where's the difference to the liability issue? Probably the result will more or less be the same. Next slide, please. What we also see is a complaints mechanism and a whistleblowing system, which needs to be implemented already according to the whistleblowing directive. So this will need to be amended. There's no explicit duty to document and report, but you will better do so in order to avoid civil liability. They will include a civil liability provision. And then next slide, please. Enforcement mechanism, which actually combines everything you can conceive of, not only enforcement and control, but also criminal sanctions, exclusion from public procurement, exclusion from public subsidies, and naming and shaming through the publication of sanctions. So there is almost nothing left out which you can conceive of. And now let's come to the next slide, please, the kind of indirect we'll skip that. The indirect application of the German Supply Chain Act, meaning the poor enterprises who are attacked from all sides. Raj and John were already referring to that. Next slide, please. If we have a look at the enterprise, who are all the actually actors who want to implement ESG or sustainability requirements and force the enterprise to go in that direction? We do see not only the contractual partners on the bottom at the right, and we see the state and the European Union and other regional companies enacting regulation. This is already something we have covered. But there are also plenty of other so-called intergovernmental or non-state actors who are called upon by the CSR in the CSR discussion to pursue ESG goals. It's not only what Raj has mentioning international soft law from the United Nations and the OECD and ILO, but it's also non-governmental organizations establishing reporting standards like GRI, investors and financiers responsible investment and finance. We see industry associations establishing codes of conduct for their members. We see the rating agencies of all of them applying different methodologies, similar but not the same with private standard setters, and also export agencies in order to finance export or to provide any kind of support. They require ESG compliance and they write that into their laws. All of them would all be fantastic if they would all go in the same direction and apply the same rules, but they are going in the same direction without applying the same rules. They are all different, and this ends up in, next and last slide, please, in a regulatory competition and anarchy to a certain extent, where the poor enterprise doesn't know what kind of rules shall I follow now. Probably the one who is making the biggest pressure, and this is usually actually the regulators, but also actually any kind of contractual partners, because they're depending on them. We see supply chain management through, of course, contracts and codes of conduct, but then we see also questionnaires which are requested to fill in order to get business at all, also for us as law firms, by the way. We see audits being executed, certifications required, trainings also for suppliers and sub-suppliers, and we see also corrective action plans. If a questionnaire or an audit generates that you are not complying with their requirements, then you face corrective action plans. Again, they are usually not identical, but they can be different depending on the priorities your contractual partners is putting forward. The ultima ratio is actually the termination of a relationship. The European directive says only termination required when there is no possibility to mitigate or to educate your supplier. So it's a last resort, but in a lot of respects, when you look to China or when you look into certain countries in Africa where you have really difficulties to establish and enforce your understanding of your values, then eventually there is no other way than to move out and let go. Which triggers, of course, a number of political issues which are not easy to take, in particular, for example, in Germany, which has really a lot of export and import with China. So what we see, that's the summary, we see a lot of challenges for enterprises coming up in the supply chain, both for those ones who are directly addressed, but also for those ones which are indirectly subject to the supply chain regulations, eventually then also of different countries, including and in addition to soft law requirements directly applied by other of their actually contractual and other business partners. So thank you very much. With that, I hand over to Raj again.
Thank you. And next slide, please. So how does the US, in somewhat contrast to and somewhat similar to the EU and Germany, link its supply chain management demands to human rights and worker rights and the rights of women and LGBTQ plus persons? Well, there are four main mechanisms that we're seeing. Nothing that looks exactly like a directive or a supply chain management law, at least not yet, but rather a bit more of a hodgepodge, if you will, First, as I mentioned earlier, in our trade preference schemes, the generalized system of preferences mandates adherence to the ILO top 5 worker rights. And then second, through our free trade agreements, USMCA, as I mentioned, and also TPP. Now, I might point out that the Indo-Pacific Economic Framework, which is emerging, is also going to say something about labor and environmental rights. Then we've got a couple of statutes, which I'll discuss in a second, the Uyghur Forced Labor Prevention Act and the new CHIPS Act, which was just passed and signed into law, and some sanctions legislation. And through these 4 devices, we get something that approximates a regime that is not quite as comprehensive, not quite as demanding, but somewhat approximates the European regime. Next slide, please. So what we've got in USMCA, for example, are the labor rules of origin. For the first time ever in any trade agreement, certainly of the United States, at least 40% of the value of a product, in this case, a car or car parts, I should say car, I mean passenger car, and 45% of a truck, light truck, has to be made by high wage labor. And by high wage labor, we mean US $16 per hour. Now, to give you a sense, that's not too demanding for the US or Canada to meet, where the average hourly wages in the auto and auto parts sector are approximately 20 US dollars. In Mexico, it's a different story. The average hourly wages there in the auto and auto sector is sort of $2 to $6. So we're talking about a significant increase. And as Professor Brigitte pointed out, you need to have accountants and due diligence to monitor what workers are being paid. We also have a labor rapid response mechanism. She talked in her presentation about dispute settlement mechanisms. Well, here we have one in USMCA, and we've already had it being used, at least on 1 occasion, where you get a judgment fairly quickly with hard law obligations and an enforcement remedy. Let's see what happens with IPEF. IPEF is not an FTA. Remember, the president does not have trade negotiating authority. The U.S. Constitution in the Foreign Commerce Clause, Article 1, Section 8, Clause 3, gives Congress the power to regulate trade. And that power lapsed a few years ago, and the Biden administration doesn't have it. So it hasn't renewed it. So we'll see what IPEF looks like with respect to labor and environmental rights, but it is part of a couple of the pillars, of the 4 pillars. Next slide, please. What we see with IPEF emerging so far, and the discussions were just in Los Angeles basically last week, is an effort to create some emergency semiconductor chip shortage mechanisms. And why are those shortages coming about? Because everyone is trying to get their supply chains out of China, partly for national security as well as labor reasons. We're also seeing an upskilling initiative focused on women and girls in the Indo-Pacific markets. And this is kind of a private public sector initiative. Several American companies, including some prominent ones, have said they will help train upwards of 7 million women in the IPEF countries over the next 10 years. So let's see what happens. Next slide, please. With respect to the statutory linkages, now we have UFLPA and CHIPS. Next slide, please. And with respect to UFLPA, this is, I think, one of the most dramatic developments in U.S. international trade law since NAFTA and the birth of the WTO. We now have a rebuttable presumption that anything coming from Xinjiang is made with forced labor. That's the rebuttable presumption. And unless an importer can provide with the evidentiary standard of clear and convincing evidence that the goods entail no forced labor, not in the inputs, not in the finished goods, they are barred from entry in the U.S. And remember, clear and convincing evidence from our evidence law is the second highest standard in U.S. evidence law. The only higher one is the criminal law standard of beyond a reasonable doubt. So unless you can get an exception, that merchandise is barred from entry into the U.S. Next slide, please. So what do you have to do? Well, this is redolent of what Dr. Brigitte said in her presentation. You've got to comply with all the guidance, all the regulations, all the due diligence rules in supply chain tracing, in management, and make sure that at no point in at least your direct supply chain did anything come in from Xinjiang. And you have to be very responsive to U.S. Customs and Border Protection. And you've got to demonstrate again by clear and convincing evidence that that your import is free of forced labor. And the result, if you cannot, is not a withhold release order, to be clear, not like the Section 337 or Section 307 withhold release orders. It is barred from entry, period. Next slide, please. And so this is a little quote from one of our CBP directors who tells you how much of a change this is in US law, very high bar. Next slide, please. And here are some of the key UFLPA provisions in addition to the basic prohibition. The Department of Homeland Security is creating a list of entities, and it's already done so actually, of companies that are already presumed or known to collaborate with the Chinese government, the Chinese Communist Party, in repression of Uyghurs, and any merchandise from such entities, regardless of where it's made, even if it's not coming from Xinjiang, is going to be barred under this rebuttable presumption because those entities themselves have, if you will, unclean hands. Next slide, please. So we've got 4 categories of such entities, and there they are for you. And I would just highlight under number 2, it's not only Uyghurs, the emphasis is on Kazakhs, Kyrgyz people, any persecuted groups, anyone who's forced out of Xinjiang. And then on item 4, notice that the US law takes direct aim at the rhetoric of the Chinese government saying, well, the programs like internment camps are really poverty alleviation, or they're pairing assistance programs. And the U.S. government in the DHS list is saying, no, that's not true. They are actually forced labor schemes. Next slide, please. Now, just to conclude a bit on UFLPA, several countries, and they're listed for you, and their parliaments have branded what is occurring as genocide. And in a very interesting report, which I commend to you, Michelle Bachelet, the former president of Chile, who herself was a victim of torture under the Pinochet regime, issued the report on her last day in office as UN High Commissioner for Human Rights, saying that crimes against humanity may have been committed. What the UN Human Rights Council is going to do with that report remains to be seen. I'm not sure yet they have the votes to actually sanction China, but we'll see. Next slide, please. So I talked a little bit about the exceptions. There's also an outside scope challenge that you can make under UFLPA to try and get your goods in. And then next slide, please. And you've got some more help from Customs. You can look at their operational guidance, as well as a DHS strategy document, which is very helpful. Next slide, please. Now, the CHIPS Act. You may say, well, what does this have to do with human rights? Isn't this really industrial policy that is kind of intervention by the central government to try and pick a winner in the chip sector and steer supply chains out of China? And that's true. And there are the ultimate, or one of the key foundations of the law is national security concerns pertaining to artificial intelligence and chips of very small nanometers, like 14 nanometers and less. To create a reliable, supply chain outside of China. And there are an array of export controls that are buttressing the act. But the act's also about human rights. Next slide, please. Because we are seeing as an incentive for companies to onshore or at least friendshore their supply chains at 25% tax credit. If you invest your chips facility in the US, where we are more confident about the labor standards, then you get a 25% tax credit. And then there's some other important provisions in terms of a national supply database. Next slide, please. And this is a pretty big tax credit, $20 billion. But guess who is not eligible for the credit, other than obviously a foreign terrorist organization? Any entity, individual or company that's subject to Chinese, Iranian, North Korean, or Russian jurisdiction. So basically, a Chinese company cannot relocate its semiconductor facility to Arizona or Missouri and get the credit. Next slide, please. Finally, we see some linkages to human rights policies in our sanctions regimes. Of course, the Russian sanctions regimes are mainly focused on the war in Ukraine and denying Russia weapons and also denying it revenues for its hydrocarbon exports. But also we are seeing many credible reports, into the thousands now, if I'm counting correctly, of war crimes. And so we're looking at almost a total embargo, if you will, on Russia. And in fact, Russia is now, by number of sanctions, the most sanctioned country in history, even more so than Iran. And we're seeing specially designated nationals by the Office of Foreign Assets Control, the Treasury Department. They are designating certain Russian individuals who may be engaged in some of the war crimes. Next slide, please. So with that, let me turn it over to our host to talk about the CLE code word.
Thank you. As we mentioned at the beginning of the program, if you are licensed in the states of Kansas, New Jersey, New York, or Pennsylvania, please enter the code word supply in the Q&A box on the right-hand side of your screen. If you're not licensed in these states, you can disregard. Once again, if you're licensed in Kansas, New Jersey, New York, or Pennsylvania, please type the code word supply in the Q&A box on the right-hand side of your screen. Thank you. And I'll pass it back to you guys.
We would be delighted to have any questions, comments, clarifications.
If there's nobody else, I will have a question for you, Raj. How does the US look at the European regimes? Because, I mean, you have taken a different approach. Now, I think there is kind of also some learning from Europe. Europe has, as John has mentioned in the beginning, is also going in that direction that any kind of goods coming from Xinjiang shall be barred one way or the other. It's at the moment a pretty much of a rough draft. And of course, the most hotly disputed this item is the question of rebuttable presumption or even reversal of the burden of proof. Because NGOs were actually asking for a reversal of the burden of proof, meaning that the enterprises importing goods from China, they need to prove that they were not produced one way or the other, including any kinds of forced labor, which is almost impossible to prove. It's a little bit similar to what we've seen already in the conflict minerals area, where also you should actually show that when you import any kind of conflict minerals from the Congo, both according to Section 1502 Dodd-Frank Act, as well as according to the European Conflict Minerals Regulation. You should show that whatever conflict minerals you import, that they have not been used and contributing to any kind of human rights violations which are happening in the Congo. So, I mean, these are kind of general kind of approaches which make it very difficult to impossible. And with the Congo, we have seen that because people could not prove that the minerals were not involved in human rights issues, the only thing they could prove was that the supply chain was Congo-free, which generated then a lot of problems in the Congo because the livelihood of a number of people were actually cut off. So how does, I could imagine that US enterprises are not too happy when they see this kind of regulatory rigor of the European Commission and also Germany, which is of course also applicable to US subsidiaries and branch offices, etc., doing business in Germany or in the European Union.
Yes, thank you for that question. It's a great question. So the US approach is less systematic and comprehensive than the European or the German approach. On the one hand, we have Section 307, and we've had it since 1930, which bars entry of forced labor products from any source. But on the other hand, generally speaking, the way we have implemented human rights concerns into our trade policy has been episodic. And by that, I mean, it's been country by country or sector by sector. So when you mention conflict diamonds, we have rules about conflict diamonds. Or when we mention a country like, say, Iran, which recently sentenced to death two people alleged to have advocated for LGBTQ rights. Well, we already have trade sanctions on Iran. But the debate that you are having in the European Union, the discourse of how about a comprehensive approach to all countries and all issues, we don't yet have. And I think you put your finger on it as to why. The concern from producer exporters would be an erosion of competitive advantage because the regime, a European style regime, would entail more regulatory compliance costs to adhere to, and would then cut into margins, which are already difficult, especially in the present climate. I'm not sure, and I'm really speculating here, that the US episodic approach of country by country and issue by issue and sector by sector is going to be sustainable in the long run. And here are two reasons why, and I'll stop there. One is, as you suggested earlier, how the German law helped catalyze action at the European Union level. What I would suggest is the European Union level action may well call attention of Congress and the president and galvanize at least some quarters in the US to action. And the second reason was, it goes back to slide 34 that you had. Now, I would encourage all our participants to look at slide 34. Professor Brigitte talked about the conflict of laws or choice of law problem that China is deliberately putting European and American companies in. We've already seen this with Hong Kong and the national security law, and now we're seeing it with laws about Xinjiang and forced labor. US and European companies are being put in the situation that if you comply with the US or EU rules, you violate Chinese law. On the other hand, if you comply with the Chinese counter rules, you violate US or EU law. That's a position all companies understandably hate to be in. How are they going to manage that? Well, one reason, it may further decoupling from China, but it may also strengthen some of the US laws and say, well, wait a second, we're not going to buckle under the pressure of the anti-foreign sanctions law from China. We're actually going to take the EU route and be resolute about our policies. And if for no other reason, it's going to come from consumers. The consuming public, especially, not to sound old, but some of the younger people are very concerned about their sourcing and are willing, survey after survey is showing they're willing to pay more for a product that is made in a satisfactory manner.
Thank you so much, Raj. I think we have to leave our discussion and continue at another time. And we hand back to Casey.
Thank you guys very much for joining us today. Before I hand it over to our next presenters, I just want to do a quick reminders on CLE credit. In order to receive CLE credit, please be logged into the WebEx platform and have it on the forefront of your screen. And if you are licensed in New York, New Jersey, Pennsylvania, or Kansas, please be sure to listen for the code word that will be given during the program. When prompted, you'll need to enter that into the Q&A section of the screen. If you don't have a license in these states, you can disregard. And with that, I will hand it over to our next presenters.
Hello, that's me, I guess. So, hi, my name is Morgan Hansen, and I am a partner in the litigation group of Dentons. I'm located in Pittsburgh, and it is my honor today to present with Maria Hubbard a presentation on maintaining the integrity of the profession, ABA Model Rule 8.4G, and its effort to improve diversity and inclusion in the practice of law. Maria is currently working as legal counsel for PayPal after a distinguished career at the University of Arizona, where she graduated summa cum laude in Order of the Coif. Sorry, I can't talk today. She went to clerk for the Supreme Court of Arizona, and then after a distinguished career in the practice of law as a civil litigator, she joined PayPal, where she currently handles civil litigation issues for them. I have had the pleasure of working with Maria on many projects, probably perhaps more than she would like to be working on with me. But I did not know until we began to discuss the opportunity to do this CLE that Maria is also an ethics maven, serving on the Arizona Supreme Court Arizona Attorney Regulation Advisory Committee, and also the Supreme Court of Arizona Ethics Advisory Committee. So today we are going to discuss ABA Model Rule 8.4. We're going to discuss what its intent and goals are, how it's been analyzed, the controversy that has blown up about it. I think Maria would agree that of all of the ethical rules that have been recently promulgated, this one has gained perhaps the most challenges, controversy, and negative publicity of any of them out there. The adoption status of the rule, its application, and where we think it might go in the future. Additionally, as we get to the end of the presentation, we're hoping to have an interactive component where we are going to provide you with hypotheticals, and we're going to ask you to participate in those hypotheticals by telling us whether you think that the conduct described is a violation of the rule or not. So with that, I will hand it over to Maria to begin our presentation. Take it away, Maria.
Thank you, Morgan. Thank you for that nice introduction. Before we get started, I did want to just do a quick disclaimer, given some of the sensitive subject matter of this presentation, that all of the views that I express are my own. They are not that of PayPal, Dentons, the Arizona Supreme Court, or the two Supreme Court committees that I am a part of that Morgan mentioned. Instead, they are my own personal views as an individual who thinks about, analyzes, and writes about ethical rules far more than is probably reasonable. And my own lived experience as a Latina in the legal field. So if you can go to the next slide, please. Look at our cool pictures. Next one, thank you. So what is this rule that, as Morgan pointed out too, that is stirring the legal ethics community, has actually been a part of a state Supreme Court case as recently as a couple of months ago, and made me feel that I should include a disclaimer to not get in trouble. Basically, Model Rule 8.4G states that it is a professional misconduct for a lawyer to engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of a number of protected classes, race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status in conduct related to the practice of law. So Morgan's going to get more into the nitty-gritty in-depth analysis of this rule, but from a 30,000-foot perspective, it essentially is attempting to make harassing or discriminatory conduct based on this wide range of protected classes as a ethical violation for which attorneys could be disciplined according to their state bar disciplinary procedure. It's limited, however, to the conduct related to the practice of law. Next slide, please. So what is the conduct related to the practice of law? The comment to the proposed rule states that it is when one is representing clients, interacting with witnesses, co-workers, court personnel, lawyers, and others while engaged in the practice of law. And some more broader categories that are kind of moving along a lot of this controversy that we're going to get into a little later. Also includes operating and managing a law firm or a law practice and participating in bar association, business, or social activities in connection with the practice of law. Next slide, please. So how did we get here? One of the things that was kind of shocking to me when I first was looking into the rule is kind of how long it took to get to this point. Back in 1994, there were actually two different groups that approached the ABA. It was the Young Lawyers Division and the Standing Committee on Ethics and Professional Responsibility, where both of these separate groups, they proposed language to specifically identify bias and prejudice as professional misconduct. But back in 1994, in the face of opposition, both of those proposals were actually pulled before they could even go to vote at the House of Delegates. Well, 4 years later, we had the criminal justice section and that Standing Committee on Ethics and Professional Responsibility. They developed separate proposals to add new anti-discriminatory language into the model rules, which culminates in comment 3 to Rule 8.4. I'll go a little bit into that in a little bit, but that is the current one that many states have adopted. Fast forward almost a decade later, we're looking at, the House of Delegates. In 2007, they adopted revisions to the Model Code of Judicial Conduct to include Rule 2.3, which was entitled Bias, Prejudice, and Harassment. And in that rule, it prohibits judges from speaking or behaving in a way that manifests bias or prejudice, or from engaging in harassment based on all of those previous protected classes that I mentioned in Rule 8.4G, but also including, interestingly enough, political affiliation as an additional basis under which shouldn't be able to harass or otherwise discriminate against. And it also calls upon judges to require lawyers to refrain from these activities in proceedings before the court. That rule did not have anywhere near the amount of controversy as this current one does, probably because we hold judges to a higher standard and would want to keep any sort of bias outside of the courtroom. In 2008, the House of Delegates proposed the Goal 3 to eliminate bias and enhance diversity. And for that goal, the ABA House of Delegates had two main objectives. They wanted to promote full and equal participation in the association, our legal profession, and the justice system by all persons, and they sought to eliminate bias in the legal profession and the justice system. Well, it took 8 years. And in August of 2016, the ABA approved Model Rule 8.4G, which we'll talk about. And it wasn't until 4 years after that, in 2020, that the ABA finally issued an actual formal opinion analyzing and discussing the purpose, the scope, and the application of that rule. But again, Morgan will talk more about that piece. Now, as you can see on the screen, this is prior comment number 3 to Rule 8.4. And a large number of states, when they adopted the anti-discriminatory language, went with this specific comment. And under comment 3, a lawyer who, in the course of representing a client, knowingly manifests by word or conduct bias or prejudice based on protected classes, but you'll see it's a much smaller range of classes: race, sex, religion, national origin, disability, age, sexual orientation, or socioeconomic status. They violate Section D when such actions are prejudicial to the administration of justice. So as you can see, this prior comment 3 doesn't include discrimination based on ethnicity, gender identity, or marital status. Next slide, please. So the ABA, in their report, the House of Delegates, in the report adopting Rule 8.3G, provided a lot of reasoning for why they thought that it was needed at that point in time. The first one is that comments are not rules. That comment 3 that I just provided is one where it falls under the fact that comments don't have the same authority as rules. According to basically every state's ethical rules, the authority is found only in the language of the rules. The ABA Model Rules Preamble says that the comments are intended as guides to interpretation, but it's only the text of each rule that is authoritative. So the ABA House of Delegates wanted to actually make it within the black letter, ethical rules that anti-discriminatory and, harassing behavior was inappropriate. Also, that scope, as we discussed, was limited. It only addresses bias and prejudice within the scope of legal representation and only when it is prejudicial to the administration of justice. So that scope is far narrower than the one in the model rule that we have now. And so they needed to go ahead and seek to broaden the different circumstances where the rule could apply. Reason being that the House of Delegates were provided a large number of reports from different organizations, bar associations, minority bar groups, different surveys, the ABA members, where there would be a need to include things like law firm dinners and other social events, because the Standing Committee on Ethical Profession and Rules, they were presented with substantial anecdotal evidence that sexual harassment takes place in such events, such as bar association events, law firm events, things of that nature. And so they wanted to expand what the conduct related to the practice of law meant to include these sorts of activities. Also, as you see there, the ABA had already brought anti-discrimination and anti-harassment provisions into the black letter of other conduct codes. We already discussed that the judicial group, and also there was also within the conduct of standards for the criminal justice, prosecution function, and defense function. Those were also additional rules that already include this language. So in those jurisdictions where the black letter rules with anti-discrimination and anti-harassment provisions have been included, the ABA did not see a surge in complaints based on these provisions. Instead, where appropriate to the ABA, those jurisdictions were properly disciplining lawyers for harassing conduct and discriminatory conduct. Lastly, the Florida Bar Survey provided to the House of Delegates and the different committees who are proposing this language found that 43% of the respondents reported experienced gender bias. Next slide, please. So more recent surveys actually reinforce that initial Florida State Bar Survey. The Women Lawyers on Guard, which is an organization, they have a report called Still Broken: Sexual Harassment and Misconduct in the Legal Profession. It is a report, the report that it issued based on its national survey, where attorneys across the United States provided responses from a large number of different organizations and minority bar associations. And the survey sought to capture information about incidents in 5 to 10-year increments, where from the present to 30 years ago, to kind of assess what is happening now and to track whether people experience changes in behavior over time, whether while they were in law school versus 30 plus years out of law school. I figured it would be relevant to point out that 22% of the respondents to that survey were actually 30 years or more outside of law school. And when participants were asked how often harassment occurred in their employment setting and how much of the part of the culture were, different from 30 years ago, based off of that 30 years ago information, as you can see on there, 51% said it was commonly or often present, 38% said sexual harassment was somewhat common, and only 10% said that it was rare, which is an improvement that we can see in current times, where those numbers were only 48% for somewhat, 25% for often, and 27% for rarely. But overall, there's only been a 17% decrease in incidents experienced in negative workplace cultures. And part of that report, if those who are interested, actually has a lot of quotes from the respondents to that survey. And the one that I found poignant was that changing the culture is very slow and very difficult. The same issues I experienced 30 years ago, I occurred today on a regular basis. And so, at least based off of that survey information and other different surveys, that it does seem as if we still have some room to go in terms of changing some of the instances of harassment. Next slide, please. Another area where there can be some additional room for improvement is that attorney demographics do not closely show actual population demographics. There's still a lot of room needed and improvement needed in terms of bringing more diversity into the legal profession. Beginning with the 2020 survey from the ABA, 2 new questions were added for attorneys who identify as LGBTQIA+ or persons who had a disability. But those results were not actually included in the 2022 report, which is where these graphics are from, due to insufficient response. So this just kind of goes to show how underrepresented those communities are in terms of the legal profession. And also, as you can see here, we have the demographics of males being 61.5% of legal profession versus female in 38.3% and non-binary at 0.2%, which is not in line with actual population statistics. Same with the with the graphic on the right, where it shows that of the Black attorneys make up 4.5%, but in the US, they're actually 13.4%. Asian Americans are pretty close, where it's 5.5% versus a US demographic of 5.9%. White attorneys white non-Hispanic or Latino attorneys make up 81% of attorneys, despite being 60.1% of the population. We can also look at Hispanic or Latino population, where of attorneys it's only 5.8% versus 18.5% of the US population. And so these numbers are based off of the ABA National Lawyer Population Survey and the US Bureau. And based off of 45% of all attorneys actually responded, so pretty decent. And more than 26 states actually provided information. So for those statistics nerds, and I apologize, I actually did go to college for statistics, that is a more than sufficient population to provide statistically relevant information. And that is me flexing my math knowledge. Next slide, please. And now I'm going to kick it over to Morgan so he can provide that analysis that I teased you all with earlier today.
Yes, and I promise you there'll be no math involved in this component of the presentation. So the question is, how does Rule 8.4G attempt to accomplish the laudable goal of limiting discrimination and harassment in the practice of law? And I will start with the idea that something that was already mentioned, this rule came out in 2016, in the summer of 2016. 4 years after it came out, the ABA issued Formal Opinion 493, which attempts to explain the proper application and understanding of the rule. It's a fascinating read, especially if you read it after you begin to understand what the controversy was that has and continues to surround this rule, and the ABA's, I would only fair to describe it, rather defensive position on how this rule is supposed to be applied. when we analyze it, we're going to give you both the plain language as you see before, and also we will weave in there the 493 clarifications, adjustments, or explanations of how the rule is to apply. So first and foremost, the rule focuses on conduct, and that conduct limitation, which a lawyer knows or reasonably knows should be harassment or discrimination, is an attempt to limit its application from pure speech to actions or conduct that is taken. That conduct must be harassment or discrimination, which are both defined in the comments, and we will discuss their definitions in a second, on the basis of these protected classes, which are tied to, in some instances, immutable characteristics of individuals, traits or characteristics. In other cases, ones that perhaps are not immutable, like marital status or socioeconomic status, but that are relevant and, as Maria said, have a long history of being in various non-discrimination codes that the ABA has adopted. And the conduct must relate to the practice of law. Additionally, there are some important carve-outs that were added to the rule from the beginning, but exist to attempt to forestall some of the arguments and controversy which bloomed anyway. One is that the paragraph does not apply for the ability of a lawyer to accept, decline, or withdraw from a representation. And the other is that it does not preclude legitimate advice or advocacy that's consistent with these rules. Now, if we'll go to the next slide, there is fundamentally a twofold justification for this rule that the ABA has adopted. First and foremost, it is to combat harassment and discrimination in the practice of law. It is to promote a better, more equitable legal practice through curtailing some of the obvious worst behaviors that can go on in the practice. That, I would view that as the individualized goal. The second is a more societal goal, which is that such conduct, when performed by attorneys, harassment or discrimination, undermines the confidence in the entire legal profession. This is a view that lawyers are exemplars of behavior. They are exemplars of the law. And if the lawyers act in a harassing or discriminatory fashion, it has a worse impact, perhaps, than another person who might do so. Now, the speech versus conduct, which we briefly discussed, I will let Maria go into how that has been interpreted, but its ability to limit the scope of the rule has functionally, I think, failed, at least to date. What is discrimination? Well, the comments describe it as harmful, conduct that is aggressively invasive, pressuring, or intimidating. Oh, wait, yeah, no, I have that backwards. Sorry, that is harassment. I have them written in my notes. Harassment is conduct that is aggressively invasive, pressuring, or intimidating. It is derogatory or demeaning verbal or physical conduct. Sexual harassment is specifically described in the comment of the rules as unwelcome sexual advances, requests for sexual favors, or other unwelcome verbal or physical conduct of a sexual nature. That is what harassment constitutes. Discrimination is the harmful verbal or physical conduct that manifests bias or prejudice towards others. They use a specific example in the 493 opinion that an example of discrimination would be the use of a racist or sexist epithet with the intent to disparage an individual or group. That would demonstrate bias or prejudice sufficient to constitute discrimination under the rule. This conduct is not this ban or limitation or ethical violation is not a universal ban on misconduct by attorneys. It has to be tethered to the specific traits or characteristics that are defined in the rule. Moreover, it is not universal in the sense that it applies outside of the context of the practice of law. Other ethical rules, such as the ones about lawyers committing fraud or crimes, apply whether or not they are involved with the practice of law. This one is tied to the practice of law. However, as Maria pointed out, there is, let's go to the next slide. The practice of law is is much more broadly defined. It is not simply appearing in court, making arguments, representing clients. It is your interaction with witnesses, your interaction with coworkers, court personnel, lawyers, and others engaged in the practice of law. It comes to operating or managing a law firm or a practice of law. It's in the presentation of CLEs or the attendance at CLE functions, bench bar conferences, things that are part of the practice of law or attendant to the practice of law, as we all commonly understand the practice of law, but are not limited specifically to the representation. How is this judged? Well, this is an important clarification that Rule 493 or Opinion 493 put into place. This is a rule of reason. And all the ABA model rules are considered rules of reason. And that means that they're not necessarily going to be strictly applied, but they're going to be applied with the understanding of the intent that goes behind the rule. And that is a standard described as objective reasonableness. Now, the objective reasonableness standard has been questioned for under different constitutional doctrines as to whether it is actually appropriate. You might ask yourself, well, how is this rule different from the rules that govern all of employers or workplaces under Title VII or other anti-discrimination laws? And that is expressly addressed in the formal opinion, which is to say that in those instances, under other anti-discrimination laws, you need to have pervasive conduct that causes a significant injury. Under this rule, it can be an ethical violation for this to occur one time, for a one-time violation of the rule by saying one offensive or horrific comment is sufficient, and that goes only to the weight of the punishment that an attorney will face for the conduct, not whether it in fact qualifies as a violation. Finally, we should talk a little bit about the carve-outs. Rule 1.6 which is allows you to take or refuse a case. Taking or refusing a case is not a violation of 8.4G. The concern here is the balance between zealous advocacy and the anti-discrimination and diversity policy that's being stated here. If for whatever reason you feel that you cannot zealously advocate for a client, and that lack of zealous advocacy then leads you to not take on a certain type of cases, for example, cases representing religious groups that are seeking to overturn LGBT laws, that you cannot then turn around and be held to have violated this ethical rule because you are discriminating against them on the basis of their religion. The zealous advocacy component triumphed over the need to avoid discrimination and harassment here. That similarly, the legitimate advice or advocacy components worked functionally the same way, which was making an argument in a court, even if that argument itself could violate this rule. For example, arguing, as in the example that I previously used, arguing that LGBT people it should be lawful to discriminate against them, is not covered by the rule. Any legitimate advice or advocacy is not targeted. It doesn't target legal arguments being made in court, made in communications, or otherwise that are compliant with the rules. It is supposed to focus on, and this is the key, on conduct that has no reasonable justification. And that was the hope when it was passed, that it would be objectively reasonably, it would be an objectively reasonable test focusing on conduct that was in no way justifiable, tied to the actions that are being described here, harassment or discrimination on the basis of these protected classes. But let's go to the next slide. It hasn't had as smooth a launch as those of us who believe in the principles that it is espousing may have hoped for. And Maria will describe for you the controversy or controversies that the promulgation of this rule have caused.
Thanks, Morgan. Next slide, please. So first, I will say that this controversy has, as my youngest first grade teacher will say, lots of big feelings on both sides of the issue. You can see on the screen, these are some quotes from certain opinions by attorney generals, law review articles, and comments from even a UCLA law professor, as well as the New York School of Law legal ethics professor, where they use conduct such as arguments against the rule fall upon scrutiny as products of underlying agendas or fantasies of creative commenters, calling it a unprecedented violation of the First Amendment. Professor Volokh says that, this is America. You're not supposed to lose your professional license because you express certain views at a CLE or at a law firm dinner. Some of the strongest language is actually from the New York School of Law ethics professor, Stephen Gillers, who says that the preposterous claim that the First Amendment entitled lawyers to make racist, sexist, and homophobic statements in connection with law practice is an embarrassment. If you go looking into the issue, there's lots of similar language, but people feel very strongly about this ethical rule. Next slide, please. And part of that is that there's a number of constitutional concerns that's been cited from those who are kind of against the ethical rule and it being adopted and being put into the black letter ethics law of different states and jurisdictions. I won't go super deep into these constitutional concerns. One, it could be its very own CLE, and we're already halfway through here. And the other reason I am not a constitutional scholar, in fact, it was one of my lowest grades in law school. Still annoyed about that.
There's no need to confess to that, Maria, in front of all these nice people.
It's okay. But regardless, it's one of those where the constitutional concerns, it is a very complicated issue with lots of different intervening areas of law. And for that reason, we're going to just kind of touch on the subject. But in terms of going in depth, that won't be the CLE, because then we'd need a whole other hour, which would be a lot. So the main constitutional concerns are the belief that the language is overbroad. It's vague, that it constitutes an unconstitutional content-based speech restriction, not just conduct, and it violates the attorney's free exercise of religion and free association rules. Basically, it can all be condensed to, that attorneys don't forego their First Amendment protections because they're licensed to practice law. Next slide, please. So with regards to the belief that the rule is overbroad, some of it is that a lot of people have a lot of concerns, as we stated, about the scope of it, where it can include the managing of that law practice, the comments at a CLE or at a law firm dinner, where essentially it furthers that regulation beyond the traditional bounds of the legal practice. The conduct related to the practice of law doesn't identify how or when an attorney could or would violate the rule. Some of that was ameliorated with the formal opinion. However, as Morgan stated, that's kind of more of a defensive posture. A lot of some of that analysis isn't necessarily found within the black letter of the rule itself or in the comments. And a lot of it relies on, we'll say, prosecutorial discretion on the part of the different disciplinary committees or disciplinary judges of the different jurisdictions. And a number of people have issues with that, in that they would want the rules not to have they would want the rules to have it be explicitly stated when it applies, as opposed to having to rely on the disciplinary judge's discretion. And then lastly, one of the main sticking points is the rule's potential to chill a lawyer's protected speech and association, particularly related to teaching or legal social events based on the fear of a bar complaint for statements made during the event. Annual conventions of bar associations, things of that nature. They just kind of have a fear that it would then stifle attorney speech. Next slide, please. The other main concern is that the ethical rule is perceived to be far too vague to be able to be applied correctly. The test for vagueness is whether the restriction, quote, is set out in terms that the ordinary person exercising ordinary common sense can sufficiently understand and comply with without sacrifice to the public interest. And the issue that for vagueness that many courts and legal scholars have is that the model rules don't define what related to the practice of law is. Especially when you consider the fact that in that comment, it says social functions related to the practice of law. Does that apply when you're out with coworkers and you're drinking and making comments? Or if you're discussing a court case that you're currently working on with the team, but more in a social setting? That isn't specifically laid out in the rule. And a lot of the people who are against the rule say that that kind of makes it fail for vagueness. Further, the language has been criticized for giving too much discretion and too little interpretive support to basically bar those regulators and other entities from coming after attorneys for language. Again, it's some of that distrust in the regulatory or the state bar disciplinary proceedings that kind of fuels that fear that, you know, we shouldn't be able to trust those to be able to apply it solely in these cases that, as Morgan said, were more of the egregious violation of the rules, not just, you know, calling someone a bad name. Next slide, please. Another main concern is Rule 8.4 in the First Amendment, where, yes, the ethical duty can result, it must be sufficiently clear to provide notice, that the rule must not be overbroad, and you have to identify the proper balance between freedom of speech or religion and laws against discrimination or harassment is not a new problem. Basically, it's more or less reducible to a precise verbal formula than any number of regulations that lawyer speech or conduct could have been that have been upheld. Things like that fraud and other different statutes that kind of limit attorney conduct. Next slide, please. Other arguments against the rule that have been cited is, you know, in the employment context, if you are an attorney who is running your own law firm, you should be regulated as any other employer. You shouldn't be able to lose your law license if, for example, you don't want to have a, you know, you fire a pregnant staff member or something of that nature. Instead, the general belief is that you should be held to the same standards as any other employer. And last, as we stated, the assurances that the rule won't be applied in an unconstitutional manner doesn't actually cure the rule's alleged constitutional infirmities. Next slide, please. So with all of those arguments against the rule, there's actually a large number of counter arguments that have been provided. As Morgan had previously mentioned, attorney speech is already more regulated than those in the general populace. You can look at Model Rules 7.1, 7.2, 7.3. It limits advertisement, solicitation of practice. It restricts the commercial speech in ways that non-lawyers are just not limited that way. It also, the ethical rules also, you know, regulate fee sharing in Arizona. There was a huge going into as to how to share fees, whether you could, whether there's a referral, whether a non-lawyer could, you know, share in those fees. These are all things that are, you know, different ways in which attorney conduct is being regulated. And, you know, if we look again at that plain text of the rule in the comments, it does limit the scope more so than those remaining rules. Like Morgan mentioned, you know, fraud, that is anything. It's not even related to the practice of law. If you know, commit a fraudulent or something that goes against the profession, then you can, you know, be disciplined on that fact, even if it's not related to the law in itself. And finally, it's one of those where the general proponents for the rule say that if you just do a reasonable reading of the rule, that prevents all of this parade of horribles that all of the people who are against the adoption of the rule have been advocating or mentioning. Next slide, please. And I should mention that in short, the rule provides that a violation may only occur when the conduct is taken against one of the delineated categories of victims and when the lawyer knows or reasonably knows that it is harassment and when it's related to the practice of law. So when the rule is read in light of its official comments, which, as I stated, further narrow its scope, the rule provides a reasonable roadmap of the potentially triggering, scenarios. And it is important to note that the rule explicitly does not regulate or attempt to regulate conduct wholly unconnected with the practice of law, despite several other long-held rules of professional conduct doing so. And it also essentially attempts to just get that conduct that, again, the House of Delegates had plenty of information and anecdotal evidence that behavior was occurring outside of the courtroom. So, constitutionality. 4 different state attorney generals concluded that the model rule was unconstitutional: Texas, South Carolina, Louisiana, and Tennessee. Pennsylvania actually recently had 2 different go-arounds of trying to adopt the rule, and both times it was shut down as unconstitutional. The most recent was just a couple of months ago. So a Pennsylvania district court found that the ethical rule incorporating 8.4G was unconstitutional because it included fatal language of, missing the words that would manifest bias or prejudice. Because it was missing that, it basically killed the constitutionality of the rule. In addressing these issues, the Pennsylvania Supreme Court approved revisions to the rule, which prohibited knowingly engaging in conduct constituting harassment or discrimination. Next slide. But the district court still found that the revised language was unconstitutional because it infringed again on that First Amendment right. The court held that changes that regulate speech and not just conduct place a burden on the freedom of expression, and also found that it was, again, that unconstitutionally vague under the 14th Amendment in violation of due process because there was that insufficient guidance to implement the rule in a precise, consistent manner. Again, going back to the fact that that portion of the related to the practice of law is not being defined, and the actual rule itself, according to the court and some of the people against the rule, not providing sufficient context or guidance for how to apply it properly. Next
Hey,
slide,
Maria, can I jump in there for 1 second? Only to say, as a practitioner in the Commonwealth of Pennsylvania, the opinion is fascinating. And one of the things it says is there's a declaration from one of my former partners in a prior life, Thomas Farrell, who is was in charge of making these determinations, that tried to explain how he would interpret it and how, what a limited and appropriate way he would interpret it. And the Eastern District of Pennsylvania said, well, that's not good enough, because just because you're going to interpret it in a limited fashion doesn't mean that the rule could not be interpreted by a different person in an unlawful, unconstitutional fashion. It was just an interesting point for us Commonwealth practitioners who all know Tom and know that he probably would try to do his very best to interpret it appropriately, but that was not enough to save its constitutionality in the Commonwealth. Thank you, Maria.
Oh, no problem. And one other point is, one of the other concerns that the court had in the second go round in Pennsylvania is that it actually had a large issue with the inclusion of socioeconomic status as a possible protected class. Essentially saying that including it would make it so that an attorney showing an aversion to another person wearing cheap suits or worn out shoes at a bench bar convention could be subject to discipline. So it kind of goes into that parade of horribles that people are saying, and whether or not the rule would be interpreted reasonably. Next slide, please. So in attempting to assuage those constitutional concerns, as well as, still try to get something on the books to help, anti-harassment and anti-discriminatory provisions in the rules, a few states, including, Connecticut, have this constitutional carve-out where they have explicitly found that, or rather they added a provision specifically stating that a lawyer's conduct does not violate paragraph 7, so that state's version of 8.4G, when the conduct in question is protected under the First Amendment of the United States Constitution, or, Article 4, Section 4 of the Connecticut Constitution. And so Connecticut, in attempts to try to get the rule passed and pass constitutional muster, has an explicit constitutional carve-out for those language. And as you can see, like on the slide here, the Connecticut rule was challenged in federal district court. The court, however, found that the challengers had no standing and dismissed the lawsuit. In their declaration saying why they would be negatively affected by the rule, they said that in their, advocacy and in their, zealous advocacy of their client, they might use harsh language. But the court ruled that the use of harsh language to help clients understand racial bias, using forceful advocacy or criticizing religious practices that, an individual would see as harmful does not fall within the explanation of what constitutes discrimination. So they look at that definition of discrimination to find that that wasn't an issue. And important for that carve out is that the court explicitly found that the plaintiff's argument that they have a real and imminent fear of effectively being disciplined under the rule was weakened by this constitutional carve out. Next slide, please. And Morgan's going to talk about what states have been doing.
Yeah, so here's the our great United States of America in many different shades of purple, and the darkest purple sets forth the states by which the 8.4G has been adopted in full or with modifications or revisions. The lightest one is not adopted, and the middle one is not adopted due to specific reasons, but they deal with bias, discrimination, or harassment in other comments or court rules. The number of states that have fully adopted it include only Connecticut, New Hampshire, New Jersey, New Mexico, Maine, New York, Vermont, and Pennsylvania. And obviously, as we just discussed, in Pennsylvania, the adoption of it has been ruled to be unconstitutional. In Connecticut, it only recently, just a few days ago, was found to be by the district court to be constitutional, but I think it's reasonable to believe that that fight may continue. Other states where it remains under consideration include Alaska, Iowa, Nebraska, Oregon, Texas, Utah, and Wisconsin. It should be noted, though, as Maria said, that in Texas, the state attorney general has already declared it to be unconstitutional, which likely makes it a difficult hill to push up. It has been rejected, outright rejected in Illinois, Idaho, Louisiana, Montana, North Dakota, South Carolina, South Dakota, and Tennessee. And the remaining states that I've not listed are either have not considered it, have chosen not to consider it, and certainly have not adopted it. But I guess the effort in many of these states continues to push forward to attempt to have some, if not it, some equivalent of it in place because of the salutary purposes that the rule itself is attempting to accomplish, which is obviously the elimination of harassment or discrimination from the practice of law. So with that, I think we'll go to our next slide. Oh, and Maria, you get to read this one because you said you would.
Yes, for those who are seeking CLE and who are licensed in Kansas, New Jersey, New York, or Pennsylvania, if you could enter the code word integrity in the Q&A box on the right side of your screen, that would be appreciated. If you're not licensed in those states, like me in Arizona, you can disregard that entirely. So just one more time, if you are licensed in Kansas, New Jersey, New York, or Pennsylvania, you should go ahead and type the word integrity into that Q&A in the bottom right-hand side of your screen so you can get that CLE credit.
Now, I'm personally not going to do it because I don't have that Q&A function, but I hope someone will witness that I knew what the word was. It was integrity. We'll give you like 10 more seconds, and then we're going to go on to try some hypotheticals and see what the group thinks about how the rule should apply. All right, so can we go to our next slide? And that is the application slide. Casey, could you explain how the polling works? Because I'm not sure, or someone from Denton's IT, how we're going to do this.
Absolutely. So as we go through these next slides, you're going to see a poll pop up on the right-hand side of your screen, asking you a simple yes or no question. The poll will be up there for about 30 seconds. Just click the box for either yes or no, however you think the question should be answered.
Awesome. Let's go to the next slide. And the first one is yours, Maria.
All right, we're going to start off with some of the easy ones to kind of wake everyone up and hopefully include in participation. We should note that We can't see who votes yes or no, so feel free to put your honest opinion on there. In this instance, or this hypothetical, an attorney represents an ex-wife in divorce proceedings and files a motion noting that the children were put in harm's way by the ex-wife's association with the ex-husband's association with an Arabic woman. So when that poll pops up, just put in yes or no, whether in your opinion this violates ethical rule 8.4G. And while you're doing that, I will mention that basically all of our hypotheticals are taken from actual court cases, legal ethics opinions, or that ABA formal opinion. So these are not entirely coming out of left field. And so we actually have some analysis, but of course, a lot of these issues are complicated. So the poll has ended. And so for those who answered yes, the answer is based off the court case Inree Thompson in Indiana. It's from 2005. The court publicly reprimanded a lawyer for filing a petition in the divorce action, arguing that the couple's children were put in harm's way by the wife's association, in that instance with a Black or African American man.
All right, great. Next slide, please. So this is a simple one. We have an attorney calling a female opposing counsel babe repeatedly during a deposition. Do we believe this conduct, or do you believe the conduct will violate 8.4G? Please complete the poll. Now, Maria, how is it that you're seeing the answer? Because I didn't see the answer.
For the hypotheticals?
Yeah. No, I mean for the poll. For the poll.
Oh, for the poll. Yeah, it's on my right-hand side. I actually can't see the responses, however, as to the percentages. I don't know if on the Denton side, that's a thing that we could be able to see.
Yeah.
The results of the polls.
Yeah, because I can see the question, I just can't see the result of it. Could we get that on there? Well, as we work through the technical difficulties, the answer to this, if we go to the next slide, the answer to this one is yes. The we'll go to the next slide if we could.
111 of you answered that correctly. So there you go. 3 said no, and 70 of you are not participating. So I will shame those 70 of you for not clicking the button. But I would say that what's in this, again, this is another one where it's a court case, is from Villaney v. Odd, and this is actually the quote from the judge. I mean, effectively, in that disciplinary action, the attorney admitted that he twice used gender-based vulgar terms to insult his defense counsel, once in person and the second time in an email. And, you know, in both of those times, the circumstances underlying the insults were directly tied to the litigation. And the court found that the use of slurs was intended to intimidate her in the representation of her client. And, you know, this kind of a conduct, along with its underlying intent, it meets that definition of harassment or discrimination. And so effectively, here is the court's very strong language, kind of calling out that attorney, saying that his actions disgrace the entire legal profession and the system of justice that provides a stage for such oppressive actors.
So that's a hard yes then. All right,
It's
Maria.
a hard yes. And so this one's mine. There is a lawyer serving as an adjunct professor supervising a law student in a law school clinic, has made repeated comments about the student's appearance, and has also made unwelcome, non-consensual physical contact of a, you know, sexual nature with the student.
Seems like a tough one, Maria. I don't know.
You know, we have to sneak in the easy ones. So maybe those 70 people who didn't respond last time will respond this time and get, you know, the positive feedback that we all crave on a daily basis. There we go. Great, if I can see those results. This one is actually from the court case Inree Griffith. This is a Minnesota case from the 2013. The basically, this is an obvious violation, and it demonstrates the importance of making the scope of the provision broad enough to encompass conduct that may not necessarily fall within the context of the representation of a client. Again, this is a law school clinic. It's not in the representation of a client. Same thing with a, bar convention or, minority bar event. In Arizona, we had an issue where that occurred. That wouldn't have fallen under 8.4 explicitly without the rule. Next slide, please. So this one's more interesting. And I forget, Morgan, is this one yours or mine?
It's yours.
All right. The judge determines that an attorney has utilized preemptory challenges in a discriminatory manner. So again, if you could just answer that question, the poll when it comes up. In this instance, a judge has already looked into the issues and has determined that the attorney did use the preemptory challenges in a manner that was discriminatory. Does this violate the rule? And this one was explicitly called out in ABA Formal Opinion 493 and is also part of the actual rule comment to help provide the scope for that rule.
Let's see the results before we give the answer. I'm curious.
Because this one's a little trickier.
Oh, yes.
Yep, much bigger split. So basically about 70 said yes and 27 said no. And in this instance, the minority wins. According to the ABA formal opinion, by itself, that is not sufficient to violate Rule 8.4G, despite the court's finding that the preemptory challenge was done in a discriminatory manner.
All right, let's go to the next one. In this one, the judge's chamber rules require a singular pronoun, he or she, be used for a singular person to keep order in the courtroom and to have a clear record in the transcript. Does that violate ABA Model Rule 8.4G? All right, can we see the results?
I have 8 more seconds, but I think we'll probably need to speed through the next few hypotheticals since we only have about 4 minutes.
Right. And we do want to get to the final thoughts.
Yes.
So the results, yes, no, no answer. This is another tough one, and the answer was yes in this instance. Now, this was under the New York Judicial Code of Conduct, which says that a judge cannot require the use of a singular pronoun because it exhibits bias or prejudice based on sexual orientation. Interestingly, under that New York Code of Conduct, that also includes gender expression and gender identity. But given the similarity between the language of sexual orientation in both codes, this would likely constitute an 8.4G violation.
And I'll just add to that for us grammar nerds that the opinion also stated that, they is a widely recognized or grammatically correct pronoun for an individual, which also raises much ire of many attorneys that they is a singular, but according to the ethics opinion that it is a properly known rule. So in this one, an attorney represents a conservative religious couple in a lawsuit where they refuse to provide services to a same-sex couple on First Amendment grounds. Does the attorney's, representation of this conservative religious couple violate the rule as, they're looking to not provide services based off of sexual orientation? And in this instance, the answer, unsurprisingly, is actually no, because we had that discussion, right? Where the black letter text underscores this by explaining that the paragraph does not limit the ability of a lawyer to accept, decline, or withdraw from representation. Though individuals may disagree with the position of the attorney that we have in this hypothetical, that would not affect the legitimacy of their representation.
Marie, why don't you do the next one, and then we'll skip to
Yes.
the final slide.
Yes, and so the next one is actually in this exact same scenario. What if the attorney instead was discussing the case at a firm dinner and states support for the client's actions because, the plaintiff's lifestyle to them is immoral? We'll just skip to the answer on that one, and that is that yes, location at a firm function would fall within the scope. Also, making discriminatory remarks regarding the plaintiffs based on sexual orientation would make this fall under the rule, because at this point, this is no longer pure advocacy. The lawyers instead, defending the position by expressing, anti-gay viewpoints, and then that kind of runs afoul of the rule.
All right, can we skip forward to final thoughts, and Maria, take us home.
Yeah, I mean, I would say that while many of us agree that the legal profession would benefit from, promoting and increasing diversity and reducing instances of harassment and discrimination, it is difficult to slice and dice an ethical rule to be able to do this effectively without also possibly infringing on those First Amendment rights. This is a very fluid area of law. As Morgan said, we even have decisions from a few days ago as to whether it's constitutional, which directly contradict nearly a similar rule from a few months prior. So this is, it's kind of difficult to see where it could go. If we look at the recent, Supreme Court cases that we have, 2018, we have Masterpiece Cake Shop. This session, there's Carson v. Macon in Kennedy v. the Meverton School District, where, allowing to have additional religious freedoms, kind of trumping anti-discriminatory provisions. And there is actually a pending case called 303 Creative LLC v. Elenis, where a website designer wants to be able to have a notice on their website that they will not provide wedding website services for same-sex couples because it infringes on their, firmly held beliefs that is not appropriate. So that is a current court case. We'll see how it all goes.
All right, well, I think we're out of time. Actually, I know we're out of time, and I appreciate everyone's patience. If you have any questions or concerns, please reach out to me. I'd be happy to try to get you some answers. And I just want to thank you again, Maria, for an excellent presentation, and I've enjoyed the opportunity to work with you on this.
Well, thank you, and thank you, Tendence, for letting me chat with you all about something I hold very near and dear to my heart.
All right, Casey, it's all yours.
All right, thank you all for joining. We hope that you can join us for our session later on this fall coming up. Otherwise, CLE certificates of attendance will be emailed to all eligible attendees approximately 15 business days following this program. Thank you again for joining.